Good evening, everyone. Hello and welcome to the final round of this year's Dean's Cup competition hosted by the Moot Court Board at Duke Law School. Started in 1963, the Dean's Cup is Duke Law's premier oral advocacy competition open to 2Ls and 3Ls. This event has a special place in my heart because I did Moot Court in law school, although I did not get as far as our finalists here tonight. Before we get any further, I'd like to thank those who helped make this event possible. Thank you to Professors Park, Boyce, and Broad, to the clerkship office staff and events office staff, and to all of the faculty, staff, and alumni who judged the preliminary and semifinal rounds. Thank you as well to the many, many students who participated on the Moot Court Board. I'm not going to read everyone's names who are in your program, but I wanted to highlight President Crystal Dillon, Intramural Chair Margaret Krusner, and the Dean's Cup coordinators, Kelly Sloan, Paul Drexler, Luisa Gomez, and Alexis Agoric. It takes a lot of work to put together a competition like this, and it's a wonderful thing to do for your classmates. 29 competitors argued in the preliminary rounds this year. From this group, 8 semifinalists argued several more rounds and submitted written briefs. Today's round features the top advocate on each side of the case. Our finalists are Katherine Thomas, representing the petitioner, Charter Day School, and Caroline Tervo, representing Bonnie Peltier, the respondent. The finalists will argue a fictional Supreme Court appeal of the Fourth Circuit's en banc decision in Peltier versus Charter Day School. The case involves the decision by a North Carolina charter school to require its female students to wear skirts, skirts, or jumpers. Parents of 3 female students filed suit against the school, alleging a violation of the female students' equal protection rights guaranteed to them by the 14th Amendment and a violation of the anti-discrimination provisions of Title IX. The case presents 2 issues. The first issue is whether Charter Day School, a nominally public charter school, is a state actor for purposes of Section 1983. The parents filed their equal protection claim through a 1983 private right of action, which requires the plaintiffs show that the defendant acted under color of state law. The second issue is whether Title IX applies to gender-based dress codes. Our finalists will argue before an esteemed panel of guest judges: the Honorable Guy Cole of the U.S. Court of Appeals for the Sixth Circuit, the Honorable Robin Rosenbaum of the U.S. Court of Appeals for the 11th Circuit, and the Honorable Justin Walker of the U.S. Court of Appeals for the District of Columbia. More information about our finalists and our guest judges can be found in the program. We do ask that while arguments are ongoing, please remain in your seats, silence your phones, and refrain from talking. Please do not applaud in between the advocates' arguments. After the argument is over, the judges will leave to deliberate. You can stay and hear their conclusion at the end. Thank you.
All rise.
Well, you may be seated.
The Honorable Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their full attention, for the court is now sitting. God bless the United States and this honorable court. We will now hear arguments in case number 201001, Peltier versus Charter Day School.
Okay, good afternoon. Are we ready to proceed? Okay.
Mr. Chief Justice, and may it please the court. My name is Katherine Thomas, counsel for the petitioner, Charter Day School. With the court's permission, I would like to reserve 3 minutes for rebuttal.
Yes, that is fine.
Thank you, Your Honor. This is a case about the private actions of a private actor. Government intervention is not necessary or appropriate to address a charter school dress code. Firstly, the applicable guidelines set forth in Rendell-Baker indicate that the CDS uniform policy does not fall under color of state law. Secondly, the ambiguous language of Title IX does not show clear congressional intent or provide clear notice that the statute extends to charter school dress codes. To successfully make a Section 1983 claim, the respondents must establish that CDS acted under color of state law, specifically when it implemented its dress code. Section 1983 erects no shield against any type of private conduct. And a state action analysis always allows for countervailing reasons that the actions of a private entity should not be attributed to the state. The leading case on whether the actions of a publicly funded, privately operated school can fall under color of state law is Rendell-Baker. Now, in this case, this court held that a school that was largely funded by the state, functioning largely as a government contractor, and heavily regulated by the state, did not fall under color of state law.
May I ask you a hypothetical about your state action argument?
Yes, Your Honor.
Imagine that it's in the wake of Brown v. Board, there's a southern state or southern school district, and it comes up with this scheme. It says, fine, we will allow black students and white students to attend our regular public school, but we'll also allow charter schools. And there's someone who applies for a charter school, and they're going to have an integrated charter school. So far, so good. And there's also someone who applies for a charter school, and they say, we're going to have 2 campuses, one all black, one all white. And the state says, okay, that's fine too. We're going to, allow both charter schools. And so what ends up happening is that all of the white kids choose to go to the charter school where they have their own campus. And the result is that all the white kids are on one campus, and all the black kids are either on the other campus or the other charter school by themselves or the regular public school. There's no integration. That scheme I just described, the charter school with the separate campuses, do you think that they would be state actors?
Your Honor, it is important to recognize that this is a state action analysis and not a state actor analysis. Thus, this court, for example, could hold that the CDS uniform policy does not fall under color of state law, whereas a fully segregated charter school...
Go back to the hypothetical, if you would. A plaintiff brings an equal protection challenge, and they say, this scheme, this charter school with the separate campuses is violating the Equal Protection Clause, and the charter school says, no, we're not a state actor, so no claim. Would the charter school be correct?
Your Honor, I would argue that a charter school would not be a state actor, but that does not mean that those students would be bereft of legal protections.
Why is that?
Because, Your Honor, charter schools are still regulated by the state, and per the North Carolina Charter School Act, must comply both with the North Carolina state constitution and the
I want you to
United
stick with
States
I know you may not want to stick with my hypothetical, but please do stick with my hypothetical. We're talking Alabama, 1958. Okay? There are no regulations in place that are going to help with integration.
Oh, I see. So in this hypothetical, Your Honor, we are in the year of 1958.
It's in the wake of Brown v. Board.
I see. In that case, I believe that while the school would not necessarily fall under color of state law, it would still have the protections of the United States Constitution.
But the Constitution is only going to regulate a state actor. And your position, I think, is that the charter school in my hypothetical is not a state actor.
Yes, Your Honor. In that case, I would amend my position to say that while this action could still fall under color of state law and avail those students to the necessary constitutional protections they needed, this is not to say that, based on that hypothetical, all charter school actions, including this uniform policy, would fall under color of state law.
Can I ask you a separate question? Why shouldn't we respect the wishes of the state of North Carolina? The Constitution provides for charter schools. The charter schools are public schools. Their employees are public employees. It seems to me that there should be a certain amount of just respect given to the wishes of the state as expressed in its Constitution.
I agree, Your Honor, that this court has an interest in respecting the desires and the intent of the state of North Carolina and its legislature. However, I would disagree that the state intended for charter schools to operate as public schools. Now, yes, per Provision 15 of the North Carolina Charter School Act, they are nominally designated as public. However, per that same provision, charter schools are to be operated by a private board of directors and to operate independently rather than as an agent of the state. In fact, very recently in Kinston Charter Academy, the Supreme Court of North Carolina held that the clear meaning of the North Carolina Charter School Act was for charter schools to operate as private entities rather than agencies or instrumentalities of the state. Thus, yes, Your Honor, we should respect the state of North Carolina's wishes, and through the statute it has created, it has suggested that private schools operate as independent entities rather than an agent of the state.
Could the state of North Carolina decide that it just wasn't going to operate any public schools?
That would give us a different analysis, Your Honor, because per one of the factors created by Rendell Baker, for a private entity's actions to fall under color of state law, the state must have fully delegated a traditional and exclusive obligation. Now, if the state of North Carolina had absolutely given up on its state constitutional obligation to provide public education, we would have a different question. However, as it stands currently, while there are charter schools operating in the state of North Carolina, there are also conventional state-run public schools for any student who wishes to attend.
Well, now let me ask you something, because the test, one of the tests is whether whether the function is a traditional exclusive state function, right?
Yes, Your Honor.
So when we're looking at a traditional exclusive state function, although it's true that there are now charter schools, there have not always been charter schools. And so why would it be wrong to say that it was a traditional state function to provide a free public education, a traditional and exclusive state function to provide a free public education to all students?
Yes, Your Honor. Because charter schools are a continuation of a centuries-long tradition of educational alternatives. Now,
but
yes, Your Honor.
Has the state ever provided them? When did the state first provide the funding for them and the charter of them and call them public, et cetera?
Well, this, I think, is a good moment, Your Honor, to take a step back and look at the text of the North Carolina's state constitution's obligation that the state provide education. Now, the state, per Article 4, Section 3 of its Constitution, must provide free public education to any eligible child in the state, as long as that child is, quote, not educated by other means. Now, while the state has not always provided alternative schooling, the state has always allowed for alternative schooling. And it shows in the very text that mandates their responsibility that there is acknowledgement of educational alternatives. But furthermore...
I'm sorry to interrupt, but I mean, it seems to me that the question we have to look at is not whether the state must provide an education of some type, but whether the state traditionally and exclusively has provided the free public education. And what's not clear to me is what you're relying on to suggest that somebody else has traditionally, as opposed to more recently since 1996, provided a free public education.
Your Honor, I would draw the scope not based on free public education, but state-run public education and its alternatives. Now, while charter schools are a relatively recent innovation, the North Carolina State Legislature has provided state funds to non-public, privately operated schools for over 200 years. So while charter schools are a new innovation, they're a continuation of alternative educational means. Now,
let me ask you this about that.
Yes.
So in Hallback, didn't we say, first of all, we noticed we defined the scope of areas where it was not exclusive state action to, as it regards schools, special education. We did not say all public education, we said special education. And didn't we say special education to show that we were looking with a narrower lens? And didn't we also use the phrase wider lens at a later point in that opinion to criticize the way that the case was being argued there as for how we should look at the subject of what is traditionally subject to state action?
That is true, Your Honor, but in Rendell Baker, this same court held that alternative education was not the historic exclusive prerogative of the state. and Rendell-Baker, since its deciding, has been universally applied by circuits in state action analyses for both private schools and charter schools until the case at issue today. Now, Rendell-Baker gave us 3 guidelines that are applicable to this case and can inform the court's state action analysis. One, as discussed, is that the activity be the traditional exclusive province of the state, which is a high bar for the respondents to meet. Further, the Rendell-Baker court held that near total or even total public funding carried little weight in a state action analysis. Put simply, funding does not transform private action into state action.
Ms. Thomas, I'm going to turn to the merits unless my colleagues want to have more state. Okay. On the Title IX question.
Yes, Your Honor.
Your brief makes a pretty lengthy Chevron argument. The Supreme Court has not relied on Chevron since 2017. So I guess my first question is, do you think that Chevron is dead?
No, Your Honor, I do not think Chevron is dead, and I do believe it is appropriate to apply it in this case.
Why is that?
Because, Your Honor, firstly, we have a lack of congressional intent on the precise issue of whether a uniform policy or appearance code more broadly falls within the scope of Title IX. In the words of the Department of Education, there is no evidence that Congress intended to authorize federal regulation in the area of appearance codes.
I can follow up with my question. If the Supreme Court's not applying a very robust version of Chevron, why should we?
Because, Your Honor, this is a particularly persuasive situation. Now, accepting that there is a lack of intent expressed in both the text and legislative history of the statute, we then can look to what the Department of Education has interpreted on this issue. In 1982, the Department of Education amended its regulations to specify that appearance codes should be excluded from the scope of Title IX, and Congress has allowed this amendment to stand for over 30 years.
What if someone founded a charter school and they called it the Handmaid's Tale Charter School? And the principal of the school got on the intercom every morning and said, "Good morning, boys and girls. I want you to know that one of our core values is that girls are less capable than boys." Do you think that would be a Title IX violation?
Yes, Your Honor, and there is a clear distinction between that hypothetical daily announcement that girls are inferior and the uniform policy that CDS has laid out in its student handbook.
Plaintiffs say that the dress code here sends a signal that girls are more fragile and less capable than boys. So how is that different than my hypothetical?
Because, Your Honor, Title IX was designed to address severe and pervasive forms of discrimination in education. The text of the statute suggests that it forbids exclusion from educational educational opportunities and overt discrimination.
I'm still not hearing where you think the gap is between my hypothetical announcement and a dress code that, according to the plaintiffs, sends the same message.
Your Honor, while the plaintiffs have alleged that skirts and skirts can be less comfortable for children than pants, that does not rise to the level of unambiguously discriminating against or excluding women from education. Now, the inconvenience they have alleged essentially does not arise to the level of discrimination alleged in the statute. It is not a cut and dry issue that this is a discriminatory policy merely because it differentiates based on gender. If that was a cut and dry issue, we wouldn't be debating the issue before the court today. Now, further,
there are lots of issues that are cut and dry that are not cut and dry that we debate before the court, and that are cut and dry that we debate before the court. So that doesn't seem like it's really the best indication of whether this is discrimination or not. And here's my concern about the policy. With respect to how it affects the educational program, we have allegations, for example, that the students aren't able to engage in, the girls aren't able to engage in some of the same activities as the boys because they're hindered by their clothes, because it's just not possible to engage in those activities with skirts or skirts on, and because they're concerned about, for example, if they climb on monkey bars, that the boys can see up their skirts. How does that not put them at a disadvantage in comparison to the boys when it comes to using the facilities of the school?
Your Honor, in this case, I would let the results of CDS speak for itself. The school is consistently the highest scoring school in the county on end-of-year tests, and the respondents themselves conceded that they were motivated to enroll their daughters in the school based on the educational opportunities that they would find there. Now, yes, these small group of students have alleged inconvenience, but the other female students at this K-12 school have not made a similar claim. Now, Title IX was to address severe
But how do we know they don't have a similar problem? I mean, it seems to me that we have to address whether or not there is actually discrimination here. And I'm not sure how your answer responds to the question of how these students aren't being precluded from participating fully in the programs and the facilities that the school offers.
In brief, Your Honor, I would, to answer shortly, the uniform policy is not gender discrimination merely because it differentiates based on gender. The uniform policy also requires that boys wear belts, which could be constrictive, and skirts and skirts are not necessarily so restrictive as to deprive the female students of access to their education. As for the use of facilities on physical education days and field days, girls wear shorts and t-shirts and a unisex gym uniform. It also bears keeping in mind that even if the department's longstanding interpretation of Title IX is not accorded Chevron deference, it would nonetheless violate the spending clause to enforce Title IX against the statute.
Do we even get to that, though? I mean, we first have to find that the statutory language is ambiguous. So I know it's kind of hard to do this, but what would you point to say is ambiguous in the statute? It's kind of a strange question, but...
No, but I understand, Your Honor. And I would say, but put plainly, the absolute lack of reference to dress codes in that statute. There is no mention in the text of the statute itself of dress codes or appearance codes more broadly. The closest we get is an exception for beauty pageants, which doesn't have a great deal of bearing on today's case. Similarly, the accompanying congressional reports to the current Title IX statute make no mention of dress codes or appearance codes more broadly. Now, per U.S. Government Accountability Office report, currently 93% of state-run public schools have dress codes, and 90% of those dress codes restrict clothing typically worn by girls. Your Honor, may I briefly conclude?
You may.
When gender-differentiated dress codes are the norm across the country, to enforce Title IX against CDS would violate both the spending clause and the Department of Education's reasonable interpretation. For the foregoing reasons, we respectfully request that this court reverse the Fourth Circuit's holding.
Thank you. You will have your rebuttal time. Ms. Tervo?
Mr. Chief Justice, may it please the court. Caroline Tervo for the respondents. Charter Day School is a North Carolina public charter school that requires its female students to wear skirts based on the view that girls are fragile vessels deserving of gentle treatment. That skirts requirement is state action, and it is covered by Title IX. I'll start with the state action issue. In particular, the test for state action is whether, under the totality of the circumstances, a private entity's conduct is fairly attributable to the state. This is a totality of the circumstances inquiry, and this court has identified a number of factors that bear on finding such an attribution. Two of those are present here and most strongly support finding state action by Charter Day School.
Do we care how the state labels the school or the employees? I mean, just calling a charter school public or its employees, public employees, does that make a difference in the calculus of totality of the circumstances assessment?
Well, Your Honor, we do care, but it may not be dispositive, so I'll elaborate. This court has held that it's not dispositive to call something public and then be done with the state actor question, but across all of the factors that we ask for state action, it does matter how the state has designed the statutory scheme that might be at issue implicating the specific private conduct at action.
And the courts have pretty much said that public funding may not be a big factor one way or the other. Is that right?
I disagree with that characterization, Your Honor. I think public funding and regulation is relevant. Again, it might not be dispositive, but I don't think it's an accurate construction of this court's doctrine to say that it has no bearing whatsoever.
In Rendell Baker, we said that there has to be some kind of coercive action, or that the state pretty much directed the action that we're talking about. And I'm wondering what that is here. I mean, you want us to apply the totality of the circumstances test, but that's not what we did in Rendell-Baker. And I'm wondering why we shouldn't apply the same test here as we did there, since that also involved a school.
Respectfully, Your Honor, that's not my reading of Rendell-Baker. I think this court did apply a totality of the circumstances test in Rendell-Baker against Cone. And the question there is what sufficient state action could transform a purely private entity's conduct into state action. So there was no state constitutional obligation at issue. The court could not identify a specific traditionally exclusive state function, which is the other important factor that bears here. So you're left with what the court did there, which is evaluate the state funding and regulation and conclude that that alone was not sufficient to make a private school. It was a private school that was receiving reimbursement funding from the state of Massachusetts. That was not sufficient to find state action when they discharged a vocational counselor. So I think it's worth...
I was going to ask Title IX question. So, you know, you started out with the quote from the head of the charter school, and that's, you know, that's a philosophy. It's not my philosophy. I don't agree with that philosophy. I don't know whether this dress code is a good dress code or a bad dress code. Maybe it makes education better at this school for girls. Maybe it makes education for the girls at this school worse. That strikes me as social science question. And I don't see where in Title IX it empowers a court to pick between different education philosophies.
Well, Your Honor, the precise question here is whether Title IX regulates dress codes. We are on remand in terms of whether the specific skirts requirement violates Title IX.
You think it does, right?
Yes, Your Honor.
It's your, so I guess, do you think I'm right that there is a social science debate about whether this particular education philosophy, which embraces kind of traditional, you might call it traditional values, there's a debate on whether that's the right way to educate children or the wrong way. You would agree that there is an ongoing debate, right?
Certainly, both
So
sides.
where does Title IX pick sides in that debate?
Well, Your Honor, I don't think it does, but Title IX does lay out standards that protect against sex-based discrimination. So to the extent that Charter Day School believes that its skirts requirement is not discriminatory, it has educational value, that would be something that through discovery and evidence you'd have to really present. The issue here is that the plaintiffs, the respondents, have presented evidence as to how the skirts requirement impacts their education. It goes beyond even the earlier comments about their...
And I take that, and they might be right, and if I were a policymaker, I might say this is the wrong way to run a railroad. This is not the way that we should run this school. Let me kind of pivot a little bit and ask whether your interpretation of Title IX runs into the First Amendment's free speech clause. And here's what I mean. I could imagine a charter school that has a very kind of new age approach, no uniforms, not a lot of rules, disdain for the bad old days. And that certainly wouldn't run afoul of Title IX, a school like that, right?
I mean,
based on what I've told
there's,
you,
yeah,
there's nothing
no
in
sex-based
violation of Title IX,
discrimination.
right? There's not, right. And so, you know, and now we have this school, and you say, well, Title IX prohibits this school that kind of embraces traditional values and kind of like celebrates the old days. And if that's the case, I think that you're interpreting Title IX to require viewpoint discrimination. And the First Amendment prohibits viewpoint discrimination. And by the way, if these school values are informed by, well, I'll just stop there. Am I right that even if you're right about the meaning of Title IX, you'd still lose because it would violate the free speech clause of the First Amendment?
I don't follow, Your Honor. I don't think that's right. I mean, there's no cause of action for teaching someone traditional values, but there is a cause of action for sex-based discrimination.
Well, they say that these school uniforms reflect our values. And you say, even if that's the case, your values are illegal under Title IX, but other values are not. New age values are not. That seems like viewpoint discrimination.
Well, I think to the extent that the school here is a public school, it is a government and a government actor, and that means that it can't violate other people's constitutional rights in the scope of performing the educational mandate that it's been given by the state of North Carolina. So I don't follow that there would be a viewpoint discrimination issue if you prohibit those schools only from the conduct which the Constitution says is not permissible.
You don't think if the government says a charter school with liberal values is legal, a charter school with conservative values is illegal, you don't think the government is acting in a viewpoint discriminatory way?
Well, then you'd have a cause of action against the state of North Carolina if it were granting charter schools in ways that are not consistent. But again, I think that's a different issue from whether an individual charter school can have policies that discriminate against students. On
Let me ask one more question, then I'll get out of my colleague's way. I worry that your suit is bad news for poor girls. And here's what I mean. There is a market for schools like this, schools with traditional uniforms. And right now, in North Carolina, rich girls can choose to go to a private school that has these kinds of uniforms, and poor girls can choose to go to a charter school that has these kinds of uniforms. But if you take away the charter school option, only the rich girls are going to be able to exercise their choice and pick a school with these traditional uniforms. So isn't your position a sort of anti-choice position that takes poor girls away from a market that exists for schools like this?
Respectfully, I think that line of reasoning counters in my favor. Let me explain. I think that finding a cause of action allows for what we have here, which is a case-by-case litigation about specific provisions. The only provision at issue here is the skirts requirement. That keeps the state of North Carolina from needing to engage in what's called maybe the nuclear option of actually revoking a charter. It's true that the girls who are the plaintiffs here like charter day school. Their parents sought it out for specific reasons, and it's very valuable to have a constitutional tort system to be able to enforce that right without shutting down the entire school, which again, I don't think my clients would really argue that charter day school is sort of not a useful and valuable thing to the community. They obviously do, but that the skirts requirement is not necessary for the school to sort of attain that, and it would still be valuable for these girls. I'll go back to the state action issue unless there are any other questions on Title IX. I do want to talk about the constitutional obligation at issue here because I think that
I'm sorry to, what words, what text do you point to? Because your argument is that Title IX is not ambiguous. We don't go any further than the statutory text, and when we look at the statutory text, we have to conclude that dress codes are included, right? That's your argument?
Yes, Your Honor.
So what language do you point to in order to make that argument in Title IX?
That Title IX prohibits no person from on the basis of sex being excluded from participation in, being denied benefits of, or being subject to discrimination under their educational program or activity.
But how does wearing a simple article of clothing preclude them from being able to obtain the same education as the boys?
Well, respectfully, Your Honor, I think the actual question is whether that broad prohibition against sex-based discrimination encompasses all educational policies, including the dress code. Charter Day School here admits the dress code is part of its educational policy. Fine, when Charter Day School promulgates that educational policy, it has to do so within Title IX's broad prohibition against sex-based discrimination. I'll note that Title IX does not prohibit any practices. That's the structure of the statute. It's a broad prohibition against sex-based discrimination, followed by very narrow exceptions. So this court has ruled that that broad prohibition tells entities what they need to comport with and provides sufficient notice under the spending clause. To hold otherwise would really be, I think, respectfully, to imperil Title IX as legislation. If we hold that Title IX must specifically name a practice in order for that practice to be covered by Title IX, it's not clear to me that any practices would be covered by Title IX, because again, Title IX does not stipulate any practices in particular. And the other thing I want to point to on Charter Day School's point about departmental interpretations, I'll emphasize that the United States Department of Education does routinely investigate sex-based dress codes. It may do so because that dress code gender differentiates and has different requirements for boys and girls. It may also do so because a gender-neutral dress code is being enforced or applied in a different way. So the Department of Education does believe that Title IX covers sex-based dress codes or dress codes in general.
But how does that inform our reading of the text? I mean, we don't get to what what the Department of Education thinks if the text is clear. And if the text is ambiguous, then we do get to that, and it seems like there was a regulation in place that was I guess overturned, or whatever you want to say, abandoned. And so now there is no regulation by the Department of Education that enforces or that has anything to say about dress codes, is there?
Well, dress codes are not mentioned specifically, but the Department of Education regulations still bar separate or different rules of behavior or providing aid or benefits in a different manner. So that is the specific regulation that the Department of Education cites when it investigates sex-based dress codes, which again, it has done routinely twice last year in 2022. So it is possible, again, that dress codes can have the effect of denying students the benefits of their education or subjecting them to discrimination because of sex. And again, that is what Title IX, both its text and the implementing regulations at issue, make clear.
I can ask another question.
Yes.
And I don't want to step on.
Go ahead.
So, imagine that a school puts on a play, and the play has female characters, male characters. The female characters wear dresses, the male characters wear pants. So far, there's no Title IX violation in what I've described, right?
Well, I think we do the Title IX analysis, but assuming that no one...
Really? You think there's a chance that I just violated Title IX? I put on a play and the girls in the play wear dresses and the boys wear pants? That might be a Title IX violation?
That they were not permitted to...
No, in my hypothetical.
Okay, maybe I don't...
I'm a public school, I put on a play.
Sure, yes.
The girls wear dresses,
Okay.
boys wear pants. Have I violated Title IX?
Well, if a girl was wanting to play a boy in the play and was told she could not because she's a girl and she needed to play a girl in the play, I think that the Department of Education might find a potential Title IX violation there.
And my question, though, the female characters in the play are wearing dresses. And
Okay.
the girls who have been cast as those female characters are told to wear dresses.
I think it's unlikely you'd have a Title IX violation.
Okay, so I agree with you. Now, imagine that the head of this charter day school said something less objectionable than what was actually said. And imagine the head of the charter day school said, you know, all the world is a stage. And here at the charter day school, everybody has a role in the play of life. And the girls will be cast in the role of traditional girls who wear dresses. The boys will be cast in the role of traditional boys who wear pants. Would that be different?
I think, again, discrimination here is treating people differently in a worse way because of their sex.
Is it different than the play hypothetical?
I mean, the purpose here is to root out sex stereotypes. So to the extent that a play becomes a venue for a school to perpetuate sex stereotypes, you have to be careful of Title IX issues. I do want to say, if there are no other questions about Title IX, one more thing about the school voucher issue, because I think that is a very important issue here. I want to note that North Carolina does have a school voucher program, but that is very different in the state statutory structure than the charter school system that it has here. So when North Carolina passed the Charter Schools Act, it created this entire category of charter schools, and it funds and regulates them just like they do traditional public schools. That is very different from the voucher system, where functionally students receive the tuition benefit from the state, and then the student gets to exercise the choice whether or not, or how they would like to spend that voucher or coupon, so to speak. So that matters. This court has held that it does matter whether the choice is happening on the government's end or the student's end. And vouchers have been held constitutional, even most recently in Carson against Macon last term, insofar as they allow that tuition benefit to go to the student and then the student exercises reasonable choices. But that's very different from here, where charter schools actually are applying to the state of North Carolina to get their charter application. They then enter into the charter agreement. That is North Carolina entering and delegating its constitutional obligation to the charter school in that moment. So the government, respectfully to my to charter day school here, the government has already intervened. It has created this charter school system. It is licensing charter school operators. It is supervising and overseeing those operators as they educate students, which again is North Carolina's constitutional mandate to do so. That is a very, very different state structure and different in meaningful ways than the voucher system. And finding for...
I'm sorry, I didn't want to interrupt you. Go ahead and finish your thought, and then I'll ask you.
Finding for respondents here would not endanger the constitutional validity of those voucher systems.
What do we make of the Supreme Court of North Carolina's opinion that that sovereign immunity doesn't apply to charter schools?
I think that doesn't have a bearing on this question because immunity and Section 1983 state action liability are often decoupled. That specific X. Rel. Stein holding merely held that charter schools are not state agencies entitled to state sovereign immunity, but that does not mean that they might not be local units entitled to some other sort of governmental immunity as local districts are. And the other thing I want to say about that is that the constitutional obligation here really extends to every single local district school. So to the extent that your honors might be thinking about how the students here had a choice, I think respectfully that consideration is not relevant here because North Carolina's constitutional obligation extends to every single public school, which includes specifically, per the terms of the charter agreement, public charter schools and also traditional district schools. If there are no other questions, thank you very much, Your Honor.
Okay, thank you, Mr. Rowe.
We'd ask that you find for the respondents.
Thank you. Ms. Thomas?
The question before the court today is not the likability of the CDS uniform policy. Some would view this policy as promoting formality and a respect for the educational process, while others would see it as an impermissibly old-fashioned set of rules. The only two considerations before this court are whether the policy falls under color of state law and falls within the scope of the Title IX statute. Briefly, the answer to these questions is no. The respondents' arguments on either of these questions cannot stand because they cannot meet the threshold requirements of either claim. Now, the respondents have not argued a compelling reason we should diverge from the previously universally accepted guidelines of Rendell-Baker. The facts are analysis, and as applied in Rendell-Baker, Cavan S., Lo Giudice, and Robert S., publicly funded, privately operated schools did not fall under color of state law. Further, the element of choice is crucial here. North Carolina has allowed for charter schools while continuing to offer traditional public schools to anyone who wants them. No parent was compelled, including the respondents, were compelled to enroll their children in CDS, and no one is compelled to stay. As Judge Quattlebaum reasoned in the 2021 ruling on this case, no student must attend CDS, and any student may still attend a traditional public school at any time.
But according to the record and what you argued in your initial argument, the education that is received at a place like CDS is the best that is locally available. And so, although it's true that parents could opt to send their children to a public school, a traditional public school, I guess, if they didn't want their children to have to wear the uniform, they would have to do that at cost to the child of the educational advantages of a place like CDS. Why doesn't that make this fall under the purview of Title IX also?
Oh, so as a Title IX question, Your Honor?
Right, because reason being that it means that the student would not be able to attain the same educational program or benefits in order to avoid the dress code and the baggage that it carries with it.
But crucially, Your Honor, the students would not be excluded from education, which is ultimately what Title IX seeks to address.
They allege they'd be excluded from a good education.
Your Honor, just because CDS traditionally has the highest end-of-year test scores and does offer a good curriculum does not mean that the students have no chance to get a good education if they should not attend the school. The respondents have never alleged that. They may not be at the school with the highest end-of-year tests, but they always have the option to attend another school. Further, extending Title IX to this case does have larger ramifications. Now, the respondents would have you extend the statute to a school play about princes and princesses, where Title IX gives the federal government, may I briefly conclude?
You may finish.
Thank you. Title IX gives the federal government an extraordinary level of control over our nation's institutions with the threat of lost federal funding. To extend that statute to charter school dress codes would give the federal government an unacceptable level of control over the minutia of what happens in our nation's educational institutions. Thank you.
Thank you, Ms. Thomas. Thank you both very much for your arguments this afternoon. They're exceedingly well presented. We appreciate your briefing and your oral advocacy. We will adjourn and reconvene shortly. Thank you.
All right.
Thank you, everyone. Please remain seated while we wait for the judges to return from their deliberations.
You may be seated. Well, thank you all for attending today's moot court finals. I think you all would agree that Katherine and Caroline, if I can use your first names, just did an outstanding job in terms of every aspect of advocacy and written products. So I do want to. You know, it is very, very difficult to pick a winner. And, you know, we're judges and we have to do that, so here we are. And, but it's just very, very close. You're both incredibly talented law students, soon to be lawyers. You'll have brilliant careers in the practice of law, whatever you do, whether it's oral advocacy or something else. So again, thank you for all your hard work. With that in mind, again, it was really, just a tough call, but we have selected their Caroline Tervo. So I guess we can leave this here for the moment, but we will take pictures. We do have just a couple of comments. And I would just start by saying, you do everything right that we always ask of the lawyers who appear before us, and that is that you're obviously very well prepared. You spent time on the written briefing. You were extremely well prepared for oral argument, and importantly, I thought you listened to the questions that were asked of you. A lot of lawyers don't do that. They come prepared to present what they want the court to hear, and sometimes don't listen to what the judges are asking. It's always important to listen to the judges' questions and make sure that you're doing your best to address those questions. And I thought you did a great job of that. So I would pass this off to my colleagues to see if they have any comments. Judge Rosenbaum?
I don't want to delay it too much further. I know you want to get your hands on this fragile vessel. But I would just say that both of you, if you appeared in front of my court, you would be right up there with some of the better advocates that we hear. Today, you would be right up there with them, even before graduating from law school. So you should both be very proud of yourselves.
I thought you were both very well prepared, had great poise, and great command of the precedents. And this was a real pleasure, largely because the two of you were so prepared.
So once again, thank you very much. So we get to take pictures? Okay.
Thank you all.
Okay.
Steps over there.
Yeah, we don't want to